It's often called, in law school, it's called professional responsibility.
I'm eating.
And this is when you take the bar exam, you actually take two bar exams. You take the bar exam, which is four or five tests, three or five. And then before that, you take a special bar exam on nothing but the subject that I'm going to be talking about today, called the MPRE. And its subject is to cover the list of things lawyers don't do. So it's sometimes called attorney ethics. It's often called professional responsibility. It may be called disciplinary rules, or they may be called the rules of attorney conduct. And what it is basically is the list of things which, if an attorney does it, the attorney can be punished by the state bar for. All right, well, what sorts of punishments do the state bar give? They don't have the power to take your money or to send you to jail. What they do have the power to do is they can disbar you. And everything about the rules of attorney conduct is based on the power of the state bar to disbar you, meaning you don't get to be a lawyer anymore. Now, not every violation of a rule will get you disbarred. That is the death penalty sanction. That's the worst of the worst. There are other things that they can do instead. They may suspend you. They may say you're not allowed to be a lawyer for a certain number of years. They may put you on a kind of probation. And it's pretty common for them to say you are allowed to be a lawyer, but you're not allowed to run your own firm. You're not allowed to be a partner. You're not allowed to be the boss. You have to practice under the supervision of another attorney. And that may last for a period of years. Or they may give you what's called a reprimand. There's two kinds of reprimand. Is the idea, you're in Catholic school or whatever, and you flick a spitball, and the nice old nun, not so nice old nun, comes around and tells you to hold out your hand while she slaps you on the wrist. Right. A reprimand is a slap on the wrist. But there are two kinds of reprimands, public and private. A public reprimand means that they are publicly going to say, shame on you, you did a bad thing, you lawyer. And they will actually write that down. And if you go to the State Bar's website and look up a lawyer, which you should always do when you're considering a lawyer, go to the State Bar's website and look up their profile. And it'll be written right there if they've ever had any discipline, including public reprimands. And then it'll give you roughly, not what they did, but what rule they said was violated. And that'll be written and it'll follow them for the rest of their lives. Then there is the idea of the private reprimand. The private reprimand is what happens when you just, they just say, shame on you, bad lawyer, don't do it again. And that's private. And a lawyer who's been privately reprimanded generally has the right to deny that they have ever been reprimanded at all. And it is not generally written. But if you catch more than one private reprimand, you're probably going to get a public reprimand. And if it carries on from there, you could be looking at something more serious. So these are the punishments for this. And the procedure for this is very stilted against the attorney. And what I mean by that is, in criminal cases, you have a right to remain silent. For violations of the rules of professional conduct, you have no right to remain silent. You must answer, and you must answer in writing. You have to say exactly what happened and provide a full account anytime this happens. And you must do this anytime anyone files a sustained grievance against you. Who can file a grievance against an attorney? Anyone. Anyone. Doesn't have to be their own client. Doesn't have to be a judge. Can be just somebody. Can decide to file a grievance against an attorney. Now, if you file a grievance against an attorney, the next thing that's going to happen is that the state bar is going to read that grievance. And they're going to figure out whether or not that grievance contains an allegation that the lawyer broke a rule. Because very often you would end up in a case where you would have the term is demurrer, where somebody says you did something, but the thing they say you did is not even illegal. This happens to attorneys all the time because we're the ones who actually know what's legal and illegal, and we do often piss people off and they say, I'm going to write the state bar about this. Well, the state bar may read your paperwork, but they're like, well, doesn't sound like you did anything wrong. And in that case, what they're going to do is they're going to send the grievance or the attempted grievance to the lawyer, and they're going to have on the front of it a page that says somebody filed a grievance against you, but we read it and there's absolutely no indication that you did anything illegal. So have a good day. You have the right to deny that this has ever happened. I have only I was in active practice for 8 years, and I guess I've been in practice 14 years total now. In that whole time, I have only had one grievance ever filed against me, and that's what happened to it. The state bar looked at it, said, well, doesn't look like you did anything wrong. Have a good day. If you attended my class I ran a while back, War Stories with Old Man Pure, I talked about the time that I called the county clerk, or was alleged to have, fine, I did, when I called the county clerk a bastard and found myself locked up in jail for the night. That district attorney, who was just outraged at my behavior, filed a grievance against me with the state bar, and a couple of months later, I got a great big stack of papers in the mail, which had this first page that said, somebody filed a grievance against you, you can ignore it. I read the first page of it, got the general idea of what it was, and threw it away. I wish I hadn't done that, because it would make for interesting material. I would have been able to present it at biography or something, because it's a wild story. But that's basically the procedure. You have no right to, and you have no right to cancel. You have to pay for your own lawyer and all the rest of it. And when a grievance is sustained, it's a big deal. Okay. So that is the procedure, and those are the ideas of evidence. Now, for the rest of this, I'm going to be talking about the substance. In other words, what are the things that a lawyer is not allowed to do? Okay, and I'm not going to talk about all of these because it's a pretty long list, and I could go on for, well, a semester is how long it takes. You take 3 hours a class for a semester is how you learn these rules. So first of all, I'm going to say that in the United States, to be a lawyer means to be a lawyer in one state at a time. I'm a lawyer in 2 states, Texas and California. And from there, you may also become a member of federal courts located in those states, and they have their own systems. However, and that means that each state has the right to set up its own system of rules, okay? So Texas may have its system of rules of things attorneys not do, whereas California may have completely different rules. But in practice, these rules are pretty much the same anywhere in the United States you go. I've talked in some earlier classes about the idea of model rules, or the idea of a model penal code, or the idea of the federal rules of evidence, or the idea of uniform acts. This is what happens when maybe the federal government, or maybe a bunch of law professors, or maybe some lobbyists get together and write what they think would be a good idea for the law all throughout the United States. And they then take those and give it to all 50 states. And most states just take it and make it the law without even reading it. Some states will take it and say, well, I'm going to change a little bit here, I'm going to remove that, I'm going to add a little bit about this, and then add it in. So in the same way that when you had my class on evidence, I said, yeah, okay, the evidence law of a state is not necessarily the same thing as the federal rules, but it's close enough that that's what we teach. Same principle here. Now, the model rules are not the law anywhere. This is a set of rules set up by the American Bar Association. In other words, law professors, ex-lawyers, people who are not actually given the power to make law. But almost every state has adopted some form of the ABA model rules. And in the Discord, I sent out a link to the ABA model rules. So if that's what if you want to know what is it that an attorney is or is not allowed to do, I would say for purposes of VR chat, that that's what you can read. In the same way that when we had the evidence class, we put in, I said, if you want to know for VR chat what, say, I as a judge am going to be making rulings on as far as evidence is concerned, I make my evidentiary rulings based on the federal rules of evidence. In the same way, I would make my decisions about attorney-client conduct based on the ABA model rules. Although another word about that, judges do not have the power to disbar somebody. What judges do, if you break one of these rules, is they simply file a grievance the same as anybody else, and then it becomes the state bar's problem. Okay. So let's get to it. I'm going to go down the list. I'm going to talk about some of these. First of all, let's start with Rule 1.1, competence. There's an interesting bit of history here in that the rules have changed, but here's what it says today. A lawyer shall provide competent representation to a client. Competent representation requires legal knowledge, skill, and thoroughness and preparation reasonably necessary for the representation. Basically, it means don't suck, okay? Don't suck. It doesn't mean you have to be good. It just means you have to not suck. If you suck, you can be held to have been incompetent. Now, if you look at the rule here, and you pull that up on the website, underneath the rule, there's a button here that says comment. And if you push that button that says comment, what it'll give you is several paragraphs about what this rule really means in practice. This is a nice little add-on. See, in the common law system, usually to figure out what a law means, a judge makes a decision based on it. But because these rules are run not exactly on the common law system in the same way, because they don't really have judges in quite the same way, there's not as much rules that really give details about exactly what this means in the sense that, a judge makes a decision and then that judge's interpretation of the law becomes the interpretation of the law. Instead, what happens is the ABA publishes these comments, these long paragraphs, which really define in detail what's going on and what that means. And for every rule that if you think a lawyer has broken some rule, or you're thinking about doing something that you think might violate a rule, then it's not enough to read the rule. You also have to read the comments, and that will really flesh it out and tell you what the rule is really all about. So in the case of not sucking, first of all, I should say that in some variations of these rules, and historically, the first rule was that a lawyer shall provide candid advice. Candid, C-A-N-D-I-D. That candid means we tell the truth, but it means more than we tell the truth. It means we beat people over the head with the truth. That's what candid means. And when a lawyer is giving advice, that lawyer should beat people over the head with the truth. That means that if you think somebody's going down for life, you got to tell them they're going down for life. And it sucks. So, you just have to be absolutely rough about it in some cases. And, if you fail in this obligation, when you succeed in this obligation, people think you're an asshole. And when you fail in this obligation, bad things happen. So that, provide candid advice. There also used to be a rule which says that a lawyer shall provide, as an advocate, zealous advocacy. That is no longer part of the rule. To be a zealous advocate means you go right up to the line. It means you do everything in your power, short of doing something illegal, to win. Okay? That's what zealous advocacy means. And, good lawyers continue to act as if that is the rule. You push all the way to the line. Lawyers are edge runners. And a zealous advocate is. But that's no longer part of the rule because, I don't know, I guess they figured that having that many edge runners around was dangerous. So you have to be reasonably good at what you're doing. Now, as a lawyer, if there's an emergency, right? If you're fresh out of law school and you're down at the courthouse and somebody comes up to you and says, please help me. Trial's in 30 minutes. My life is on the line. And you don't know the first thing about the case. You are allowed to go in and take that case. You can do that because it's an emergency. And the thing about representing the poor, which is mostly what I did, is fucking everything is an emergency. These people do not seek counsel unless it's an emergency. They can't afford it. So therefore, I often felt like a field medic or, just going into from one emergency situation to another. But for people who are, representing business law or something like that, you're expected to not take on a case unless you're competent to handle it. Now, here's the thing about that. Lawyers are presumed to be competent, okay? That means that you may be fresh out of law school who's never handled a case, but unless it's specifically shown that you failed to exercise competent representation, you will be presumed competent. Doesn't matter. You could find yourself walking into a multiple murder case, fresh out of law school with death penalty on the line, and you may be totally competent. In fact, the law will presume that you are. The only exception, in the United States, when we talk about specializations, there are such things as specializations among lawyers, but mostly these are for purposes of advertising. For purposes of who's allowed to handle a case. If you can handle any case, you can handle every case.
Question?
As far as your right to do so in terms of competence. There's only one exception to that I know of, which is that you need to take a separate bar exam if you want to work with patents. Right? I'm not allowed to work with patents because I haven't passed the patent bar. But other than that, I'm legally allowed to work on any case that comes to me. Anything from family case to a multi-million-dollar contract to a death penalty case. Just because I have that bar card. Okay?
Up your question.
And so you have the right to do that. But if you fail to provide competent representation, you can be fucked. Now, I want to talk about the consequences for failing to be competent, or rather, what can happen to a lawyer who sucks? All right. First thing that may happen to if you suck is that you can be held to have violated Rule 1.1 of the model rules. And you know what happens when you do that? Well, you can get disbarred, like I've been talking about, or reprimanded or suspended. But other things may happen to you if you suck. If you fail to exercise the adequate care of a reasonable attorney in your position, then you can be sued for legal malpractice. And you sue an attorney for sucking, it's called a legal malpractice action. Another thing that may happen to you, in a criminal case, if you are the defense attorney in a criminal case can be held on appeal to have provided what is called ineffective assistance of counsel. The Sixth Amendment to the United States Constitution says that a person has the right to counsel. Well, when it says counsel, it means what's called effective counsel. What does effective counsel mean? It means counsel that doesn't suck. It's a little more complicated than that. There has to be a material chance of a different outcome, and there has to have been a and there has to have been a major deviation from the norms of the profession, and it's really rather rare to do that. Now, it is rare that an attorney is actually faces any consequences for sucking. Why? Because nobody is really that capable of saying when an attorney sucks, right? They can make basic mistakes. They can miss deadlines. They can miss statutes of limitation. They can fail to give advice that is absolutely in the form, right? If you do something that is so demonstrably stupid, right, the legal equivalent of the doctor cutting off the wrong leg, then in that case, yeah. But here's the thing. Lawyers are smart people, and there aren't very many of us. And in the same way that it's really difficult to catch a doctor when they fuck up, it's really difficult to catch a lawyer when they fuck up. Because the only people who are really qualified to say when a lawyer or a doctor has fucked up are other lawyers and other doctors. And those other lawyers and other doctors have better things to do than sit around and watch over each other's shoulders. And of course, to be one of the lawyers who goes around fucking up with other lawyers, you get shunned. You don't get invited to the bar. Okay? So that's 1.1. That's competence. That's the don't suck rule.
Pierre, I have a question.
Okay. Then, yeah.
So basically, I'm just trying to understand about the whole concept of competence as it is. So let's just say, for example, I'm just saying that out of the blue here. So let's say, for example, in a criminal case, the state appoints you a lawyer as it is. Is there a difference between taking up a case of that criminal case versus a state appointing you one?
That's a very good question. The answer is not really. You could see it from one point of view. You could say that, well, the Sixth Amendment gives you a right to a lawyer, and therefore, if you pay for your own lawyer rather than have one appointed to you, then wouldn't that mean that the lawyer that you pay for would have greater right to suck than the one the court gives you? No, not really. There is such a thing as ineffective assistance of retained counsel, just like there's ineffective assistance of appointed counsel. By the way, what happens when someone is found to have committed ineffective assistance? Well, what can happen, first of all, it's rare that anybody actually is, because that would involve the court ordering new trials for people charged with serious crimes. And, you know, when you talk about appeals, right, many appeals are written on notebook paper in pencil because people who are in prison don't get access to computers. And the appeals courts look for anything they can to throw those appeals out. Oh, they forgot to put a comma here. And something like 98, 99% of these from jail appeals never see a judge, because the judges tell their clerks, find something wrong with as many of them as you can and throw them away. Or not throw them away, but just deny them without any analysis. And so most of these go nowhere. But every once in a while, something gets through on an ineffective assistance of counsel claim. Okay, what happens when it does? Well, if you can successfully show ineffective assistance of counsel at an appeal or at a post-conviction writ of habeas corpus, then what happens is the defendant gets a new trial, hopefully with a new lawyer. And what happens to the lawyer in that case? Well, in theory, nothing, but in practice, quite a lot. In practice, in order to get appointments, most courts will have lists of the attorneys who are able to take cases, and most of these courts, if you have ever been found to provide ineffective assistance, you're done, right? So in practice, if you're a defense attorney and you get to have committed ineffective assistance of counsel, you're out of business. It's over, because poor people are not going to be paying you money. They don't have it. So you have to be pretty careful about that. And there are real conflicts that arise, because sometimes you find yourself in situations, I mean, when somebody is just the faintest hint that somebody thinks maybe you might have made a mistake, you get, oh my God, if I'm found to have committed ineffective assistance of counsel, I am out of business. And different lawyers have different ways of handling this. Some lawyers simply say, I have a right to remain silent. I'm not saying anything to you. Go away. And they make the account right there. That is largely unethical, because you have, and I'll talk about this later if we get to it, an obligation to your former clients. And that means you have an obligation to come clean, to say exactly what you did and why you did it. And as a decent human being, that's what you should do. Because you may be, as an attorney, feeling, oh my God, I'm going to be out of business. I don't know. I'm so scared of this. But that person, they're in prison. And their situation is way worse than yours. So, rebel up and come clean about what you did, you'll probably be fine anyway. And that's not necessarily a good thing, right? Because then you say, oh, well, they found I didn't do anything wrong. That means I'm a good lawyer and I'm okay. Well, yeah, but then this person you were supposed to protect is still in prison, and that sucks too. But, that's what happens with that. Any other questions about that? Okay, moving on.
Yep.
All right, let's talk about, let's see, Rule 1.3 says diligence. It just means prepare, 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 prepare. They say Boy Scout is always prepared. No such thing as prepared. I'm not prepared. I'm just always preparing. Reality is going to fuck you up in ways you cannot imagine. Bye, Kip. Let's see. Communication. Okay, there's some things that a lawyer has to tell their client. First of all, a lawyer must properly inform client of any decision or circumstance with respect to informed consent as defined by the rules. If something happens in the case that's important as a lawyer, you have to tell your client. Now, the state bar, every state bar puts out a magazine, a paper magazine, and every lawyer in that state gets that magazine every month. It's included in your bar dues. And that magazine, in about the middle of it, has a list of every lawyer who has received anything higher than a private reprimand. And that list will say what the name of the lawyer is and what rule was violated. And like 95% of the people who were punished, who were disbarred, were punished for failing to keep their clients reasonably informed as to the status of a case. Why does this happen? Well, somebody comes to you and they say, I've got this bad problem, and you got a light bill to pay. And you say, well, I think I can handle that case. I mean, I don't know exactly what I'm going to do, but that sounds like something I can handle, sure. So you take the case. Then something else comes up. Your phone ring, you start saying, I'll do the research tomorrow. I'll do the research tomorrow. I'll do the research tomorrow. After a couple of months, your phone rings. And you go, oh shit, it's my client. I haven't done the research. I want to tell him that I have done something on the case, but I haven't done anything on the case. So I'll duck the call just this once, do the research tonight, and then call him back tomorrow. Something else comes up. Now your client's calling you all the time. And now, never run from your clients, because the next thing that's going to happen is they're going to file a grievance against you, and you're going to get in deep shit. Okay? So the rule of good lawyering, what I teach my students, the best advice you will ever give a lawyer, make and keep this promise to all of your clients. I will talk to you until you are tired of talking to me. I will talk to you until you are tired of talking to me. Never, never take a client and say, I'm busy, I can't talk to you right now. I mean, maybe, I'll talk to you later, I'm in trial or something. But the client should always feel that you have talked to them until they can't stand it anymore. And this sounds difficult, but it really isn't, because it's so much harder to talk about your own problems than it is to talk about somebody else. So here's what you do. You say to your client, I will talk to you until you're tired of talking to me. And then they'll think, bullshit, he's not going to do that. And they will test you, and you'll spend 4 or 5 hours talking to them about every detail of the case. And then they'll go, okay, well, I'm pretty tired now. And you say, you sure? You got more? We need to talk some more? Do we? And I say, oh, I'm good. And then you're calling them every week or two. 2 weeks is the general rule. Never let a client go by without some kind of contact every 2 weeks. And then you call them, and what you hope happens is that they run from you. That they go, oh, no, I don't really want to talk about my problems today. I'm having a nice day on the beach, whatever. Are you sure? Because then if something goes wrong, they will know that you have served them until they couldn't stand it anymore. And it actually will become easier. It's far easier to talk to your clients until they run from you than it is to run from them, and it's crazy dangerous to run from your clients. Don't do it. Now, you have to also, there's certain decisions a client is allowed to make. So they need to know the status of the matter and any relevant limitation on the lawyer's conduct. So if there's something the lawyer is not allowed to do, then the lawyer has to say, I'm not allowed to do that. So you're asking me to do something that's against the rules. Okay, let's talk a little bit about money. Not really my strong suit, as it turns out. I'm a good lawyer, I'm a bad businessman. Um, but generally, a lawyer's not allowed to charge an unreasonable fee. What's an unreasonable fee? I don't know. Last I heard, it was a few years ago, it was generally unacceptable for a lawyer to charge around a little more than $1,000 an hour. It's probably a good deal more than that now, adjusted for inflation. And it
Wow.
used to be that if you take a case for a percentage, used to be you really shouldn't take more than 30% or 40%. I think I'm hearing cases are being allowed to go as high as 50% in this case, but
50.
don't hold me to that number exactly. But that rule is kind of being eviscerated quite a bit, and they have factors that help a lawyer figure out how much to charge, and that's not really all that relevant because it's really gray and it could mean anything to different people. Uh, okay, now let's talk about confidentiality. Now, if you have my class on evidence, you understand that privilege is the idea that there are certain secrets which a court is not allowed to hear. Confidentiality is the principle that there are certain secrets you're not allowed to tell. And there are certain secrets a lawyer's not allowed to tell. You are required to take reasonable care to preserve the secrets of your clients. There are a few times when an attorney is permitted to do this to prevent reasonably certain death or substantial bodily harm. If somebody says, I'm going to kill my brother tomorrow, you do generally have a right to tell the brother. In some states, it's not a right, it's an obligation. But most states say you have the right, but not the obligation to tell the guy's brother, your brother's going to kill you tomorrow. Just imagine yourself in that situation. Just imagine yourself in that situation, right? Somebody tells you, I'm going to kill my brother tomorrow. And you look at the law, and the law says you can choose to tell that person's brother, or you can choose not to. Good luck sleeping tonight. Anyway.
Wait, is there a reason not to? Is there a reason to hide it actually? Once again, because I'm like a little bit
Well, I
confused
mean,
now.
To prevent reasonably certain death or substantial bodily harm. Maybe that's a bad example, but how certain is reasonably certain? And this is a client of yours, right?
Yeah.
Because if you tell a secret when let's say, maybe you're just being paranoid. Maybe, I mean, if it just tells you straight up, I'm going to kill my brother, then yeah, okay, it's probably reasonably certain. But, if there's intimation or something like that, rarely does anything ever go so cleanly. And, you can find yourself in a situation where on the one hand, I can be disbarred if I tell this person's secrets and it's not reasonably certain.
Oh,
But if
that
it
kind of
is
thing.
reasonably certain, and by the way, somebody may get seriously hurt or killed over this whole thing, right? These are gut-wrenching decisions, I imagine, if you ever had to make them. Anyway, so to prevent the crime from committing crime or fraud, and the certain to result in substantial injury, if they're trying to steal somebody's money and they're using you to do it, then you can do that. Or to mitigate substantial injury, to secure legal advice is a good thing. One thing you can do as a lawyer, you can talk to another lawyer to get legal advice for yourself. And as a lawyer, yeah, you do that often because, because it's a wild world. So, to establish a claim or defense on behalf of a lawyer, if they sue you, if they file a grievance against you, if you have to defend yourself, then you're allowed to use their secrets to defend yourself from them, because it wouldn't really be fair. I mean, to say, I'm going to sue you, and then you say, well, okay, and then they put on their case, and then if you tried to say, but none of that's true, then they say, confidentiality. No. If they're suing you, then you can take the gloves off, is the general rule. To comply with other law or court order, if a judge orders you to give a secret up, you have the option of doing so. And in that case, you probably should, because if you don't, then they're going to hold you in contempt. And if you get held in contempt, it's not uncommon for the state bar to see about disbarring you just for that. Okay. Or to detect and resolve conflicts of interests. So if you have, only if there's not otherwise prejudice. Okay, that brings me to, let's talk next about conflicts of interest, which is what Juicy specifically asked that this class be about. Okay, so this is the general rule. A lawyer shall not represent a client if the representation involves a concurrent conflict of interest. Concurrent conflict of interest. Conflict of interest exists if representation will be directly adverse to another client, or a significant risk representation will be materially limited by the lawyer's responsibility to another client. All right, basic case, the simplest case of the thing you are not allowed to do. If A is suing B, you are not allowed to be the lawyer for both A and B.
Oh, okay.
That should be pretty fucking obvious,
Yeah.
right? But it can get more complicated than that very easily. Because if one client will be directly adverse to another, this may happen. And I told you when we were doing War Stories with Old Man Pure about my case representing the Houston Black Lives Matter protesters, where I was representing 8 and then 3 of them pled, and later it was 5 people taking 5 protesters to trial at the same time. The judge was very, very nervous about my decision to represent 8 different criminal people, 8 different criminal defendants, because they said this is just an ethical nightmare waiting to happen. You can't do that. And I said, yes, I can. Because here's what often happens. Let's say that, Bobby and Jimmy are riding in a car. Bobby's driving, Jimmy's in the passenger seat. And in the center console of that car, you've got, a bag of drugs, right? Bag of cocaine, whatever. And the cops pull up, pull them over, run a search, drug dog comes out, whatever. They get the cocaine. It's in the center console. It's not obvious whether the cocaine belongs to Bobby or Jimmy or both of them or neither of them. Okay? Well, of course, what you would prefer to do, what Bobby would prefer to do, is to say it's Jimmy's cocaine. And what Jimmy would prefer to do is he'd prefer to say it's Bobby's cocaine. And in such a case, the ordinary course of things is both Bobby and Jimmy walk. They just walk, because you can't make proof beyond a reasonable doubt against either one of them. But what if Bobby and Jimmy had the same lawyer? That would be a big problem, right?
Oh.
Because it would suck for that lawyer to turn around in one case and say it was Jimmy's cocaine, and then around in the other case say actually it was Bobby's cocaine. We feel like that would be just a little bit two-faced, even for lawyers.
Wait.
So that's generally not allowed. Now, when I was taking on generally it's frowned upon for co-defendants, people who get arrested together, to have the same lawyer.
Oh.
But in protest cases, in my case where I was representing 8, later 5 protesters, the judge was, really nervous. I said, "What the hell are you doing?" I said, "It's fine, because this is not a case like Bobby and Jimmy. In this case, what's going on is these people are alleged to have committed the crime together of blocking a roadway, to wit by linking arms.
Oh.
And in that case, the fact that one of them is not guilty does not make another one guilty, right? In fact, if one of them is not guilty, in this case, it actually makes it less likely, not more likely, that the others are guilty. So in that case, their interests were not adverse, and I was therefore allowed to take it. However, in order to do that, I was required to get written consent from every one of them. And what I had to do is I had to write a letter. And this, by the way, everyone involved in this has given me full permission to discuss the details of the case, so I'm not violating any conflict or any confidentiality rules by saying so. What you have to do is you have to write a letter where you explain the details of the case. It's not a simple form you fill out. You explain the details of the case, and you come up with everything that you think could possibly go wrong as a result of you representing every single one of them. And then you get them to sign it, saying that they agree to it. And in that case, provided their interests you don't reasonably believe that their interests will turn against one another, you can then continue. Okay. So that's the basic rule of the conflict of interest. Now, of course, it is entirely possible for a lawyer's own interest to conflict with that of their client, right? If you own stock in Apple, then you should not be suing Apple, okay?
Oh.
Because the idea is that you want, as a stockholder, you want Apple stock to go up, but as a lawyer you want to take their money, which will cause their stock to go down, and we feel like that would be a little bit two-faced. So that's a basic idea of a conflict of interest. There are actually many kinds of conflicts of interest. You can also have certain kinds of conflicts of interest, not from someone who's currently your client, but from somebody who used to be your client. So if a lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to interests of former client, unless the former client gives informed consent confirmed in writing. If you have ever worked for somebody, you are not allowed to work for somebody else in a way to hurt your former client unless your former client consents to you doing so in writing. Okay? And this is a real situation because attorneys represent hundreds or even thousands of people. And by the way, when I say you are not allowed to represent such a person, I mean your entire firm is not allowed to represent somebody like that. So if you work for a firm and it's got 100 lawyers, if just one of them has represented somebody in the past with an adverse interest, having somebody else work on that can cause major problems. And there are ways around this, which they may have set up, clear policies. Some firms may set up clear policies where they'll say you and you are not allowed to talk to each other, and they can sort of get close to the gray line with them. In the old days, they called that a Chinese wall. In modern California, they call it a firewall.
Question.
But neither term is. The first term is kind of racist, and the second term is inaccurate and confusing. Anyway.
Here, hold on for a second. This is actually another question about that. So let's say, for example, there's two clients as it is. I represent one client, and there's just somehow another attorney that represents the second client. But somehow, I don't know what the frick, like how this could happen. Also, too, the attorney that represents the second client is also as an employee at the same firm as me. Would that be conflict of interest by any chance?
Wait, hold on. You're talking about an attorney representing an attorney?
No. So if I'm an attorney representing one client, right? And they're suing they're suing the other person as it is, right? That person.
Okay, so you're representing A and you're suing B.
Yeah.
Okay, go ahead.
But B's attorney happens to work in the same law firm as me.
No. Stop. No bueno. Don't do that. That's an obvious, because you're not allowed to represent two people in the same matter.
Oh no, not me. Not me. But I'm talking about the person. I'm not.
I understand, but your firm is you.
Yeah, basically, yeah.
Right. You are. I mean, this is. Yeah. When you're part of a firm, you're not allowed to take to the whole firm's. If one person has a conflict of interest, the whole firm has a conflict of interest. And so. Well, if you handle hundreds of cases as a lawyer, and if your firm has, 30, 40 lawyers in it, that's thousands of cases. Every case contains not one person, but many people, right? Every case usually involves 10, 20 people. So do the math. That's a tremendous number of people who are involved in this. What do law firms do? What they have is they have something called a conflicts database. It's just a thing where basically, if you're doing your job as a lawyer, every time you meet someone, especially if it's a client, but also if it's an enemy or if it's a material witness, you have to write that person's name down and as much information about them as you can, so that later on, when somebody comes to you, they give you their problem. As soon as you meet them, you plug their name into the database and see if it comes back. And if it goes conflict, you go, never mind, get out of here. And as they tell you their story, they may give you a name. And every time they give you a name, you punch that name into your database. And if it pops up red and goes, conflict, and you go, oh, shit, sorry, get out of here. You can't take that case.
Okay,
yeah. That's
Okay.
that's no good. You're not allowed to do that. Uh, and right.
Okay.
Okay. So there are a couple of exceptions. There is such a thing as an attorney as a mediator. You can say, say this happens sometimes in divorce cases where somebody, two people will come to a lawyer and they say, we don't want you to represent either one of us. What we want is for you, great and wise pillar of our community, please help us settle our difference peacefully. And that's the role of the attorney as mediator. You can do that in some cases, and there are lawyers who specialize in doing that. But the rule is this: if you fail to make peace between those people, you cannot take sides in the coming war. You're done. Okay? You just have to back out. And maybe later on they'll come back to you and say, try again to make peace. But if you play the role of peacemaker and fail, you are not allowed to take sides in the coming war. You have to just back away. And then all those people get added to your conflicts database too. So, okay, so that's the basic idea, and there are special conflicts of interest for former government officers and employees. You may have a case where, say, a judge was a prosecutor. A prosecutor becomes a judge, right? And while that judge is a prosecutor, they are prosecuting some person, and then later on they become a judge. They are not allowed to be the judge of the person they were formerly a prosecutor of. Okay? That would be a conflict of interest. But we're not talking about the rules. Judges have an entirely separate set of rules. Judges are bound by the attorney rules. They're also bound by a separate set of rules for judges, and I'm not going to go into that in any more detail. Let's see. Organization as client. This is for people who represent organizations. The most common kind of organization that lawyers represent is, of course, a corporation. And when you work for a corporation, I've known some corporate lawyers. I've never done this because, I have principles. My rule is I'll work for child molesters, but not corporations. It's just unethical. But what a corporate lawyer does is they come in and they say, all right, they bring in everybody, all the important people, and they sit them around a table. And they say, you see this table here? This table is my client. You, Mr. CEO, you, Mrs. CTO, you are not my client. If you give me some information that says that you're going to hurt the company, you just gave me information that says you're going to hurt my client. You know what a lawyer does when you tell them they're going to hurt their client? They defend their client. And I'm going to defend this client right here. And there are rules actually for purposes of giving out information. Say you're a lawyer for a big company, and say that company is doing something which the rule says will hurt your client. Right? Let me give an example of something that might hurt your client. Let's say that you've got a company that's illegally polluting a river, right? Now, as a human being with a soul, or some simile thereof, you would hope that you would be able to say, they're polluting the river, that's bad, it's illegal, I'm going to stop it. You can't, because you're a lawyer and you have to keep these people's secrets. But what you can say is, wait a minute, if they pollute the river, they'll probably get caught. If they get caught, they'll probably get sued. If they get sued, that will hurt the company. And my client is the company. So, what I'm going to do is this. I am therefore allowed to protect my client. But there's a procedure for it. The first person who tells you we're polluting the river, you go to that person's boss. If they say, I don't care, you go to that person's boss. If they say, I don't care, you go to that person's. You go all the way to the top of the chain of command. If once you get to the very top of the chain of command, your CEO, your president, if they say, I don't care, you are then allowed to whistleblow. Okay? But these are the rules for that. Okay. Let's see here. Client with diminished capacity. This is for representing people with mental health issues. This is a special issue for, let's see what it says about that. Maintain a normal client relationship if possible. If you're unable to do so, then you may take reasonably necessary protective action, including consulting with others. Okay, so let's see. Let's talk about safekeeping property. Sometimes it's a lawyer's job to hold on to stuff. And the main thing that you hold on to for people, sometimes wills, sometimes papers, but often money. You're given money to hold on to. And it is your obligation to segregate, meaning you cannot put their stuff with your stuff, right? You want to have, at a minimum, a cardboard box with a label on it saying whose it is. And maybe you want to have their own safety deposit box, whatever it may be. And that, of course, goes for computer files. You don't want to mix stuff. And you definitely do not want to mix money. Now, if they give you money, what lawyers used to do is they would put it in a bank account. And in some cases, they still do just put it in an ordinary bank account. But if you put it in a bank account to save, then the kind of a bank account you're going to put it into is a savings account. And what do savings accounts do? They get bigger. They generate interest. All right, so what if somebody gives you $1 million and says, hold on to this for me for 10 years, and you put that in a savings account? 10 years goes by. It's now generated interest. I don't know, a couple $1,000. Now, who owns that couple $1,000? You, the lawyer, because you have been, you were the one who owned the bank account? Or them, the client, because they had the money that went into it? Answer? That used to be a real problem. Today, we know the answer to the question. You don't get it. They don't get it. The state bar gets it. Because you have to, as an attorney, maintain something called an IOLTA, Interest on Lawyer's Trust Account. It's a very special bank account. And what happens is it's basically a savings account, or it's a special kind of account. You can take money in and out of it. And you have to maintain the books so you can account for whose money's in it. It's okay to have just one for your whole practice. And whenever that account generates interest on the monthly, that interest goes directly to the state bar, and they use it to set up charities and things like that. Okay, so that's the idea of safekeeping property. Oh yes, declining or terminating representation. Okay, so if you're hired as a lawyer to do a job and there is no case, there's nothing on the books that has any pleadings filed, you can just quit whenever without permission. You might need a reason for it. But you are not allowed, if the case is ongoing, whether you are appointed or retained, you are not allowed to just quit. Right? You are a slave. You have to do the job unless the judge lets you go. And sometimes the judge does not let you go. And you need to have a reason for having the judge let you go. The most common reason is, I'm not getting paid. But it may also happen that you take a case, you think you don't have a conflict of interest at the time, and then suddenly some name pops up in your conflicts database and you go, oh shit, I had a conflict. Now you can go to the judge and say, I have a conflict, I need to get out. But it may happen that the judge says, well, too damn bad. I'm not letting you out because we're set for trial in the morning, and I'm not resetting this case for another 6 months while some other lawyer gets up to speed. You should have done the job to begin with. And then, you've got to take that case and see it all the way through. And so you have to have grounds to get out. Generally speaking, judges are pretty good about, I don't know if it's pretty good. Frankly, it pisses me off. I think judges are too good about letting lawyers off who want to quit because they don't want to get paid. Because in criminal cases, it's very common for lawyers you'll go to a lawyer and they'll say, it's going to be this much money flat fee if we don't go to trial, and that much money flat fee if we do. And yeah, we'll take payments. And you take payments. Well, I'm here to tell you, I'm a good lawyer, I'm a bad businessman. When you agree to take payments from people who are desperately poor, you're probably not getting paid, right? I think it's the 6th crack commandment That goddamn credit debit, you think a crackhead paying you back? Shit, forget it. Yeah. So, you're not going to be making that money and in that way. But what a lot of lawyers will do is they'll take that money as it comes, as it comes, as it comes, and when they start missing the payments, they'll go to the judge and say, I want out. And the judge, very often where I come from, will let them out. That always pissed me off. I didn't want to do that. It seemed to me that if I was going to sign up for a fight, I was going to finish the fight. That they shouldn't, because otherwise it's just like, you take money just for what? Putting on a nice suit and showing up and signing some papers? If I'm going to take your money, I'm going to take your money because I'm going to fight for you. And as a result, I got a lot of trial experience and no money because you get ripped off all the time. Okay, so let's talk about the rules of a counselor. Right? So, okay, now let's talk. All right, meritorious claims and contentions. No, do not make frivolous claims. Don't walk into court saying stupid shit. And yeah.
Your Honor, he's filled my lollipop.
Right. Do not walk into court saying stupid shit. And don't lie. This is an interesting thing. An attorney is not allowed to make material misrepresentations. In other words, attorneys are not allowed to lie. You mean they're not allowed to lie in court? That's right.
Perjury.
You mean they're not allowed to lie in business? That's right. You mean they're not allowed to lie even if it's got nothing to do with being a lawyer? That's right. You mean they're not allowed to lie like to anybody? Yeah. That's right.
That's perjury.
It's like part of the Jedi code. If you've ever played Among Us with me, you know I suck at it because I have no practice lying to people. So, let's see. Fairness to opposing party and counsel. You're not allowed to state things about if you know that what you're arguing is against the law, you have to say that you know it's against the law. Impartiality and decorum of the tribunal. Oh, trial publicity. There are rules about, you're not allowed to go in and, talk a bunch of shit in the press about the case. You can only give very general professional information when the reporters come to talk to you. You're not allowed to take a case if you are likely to be a major witness in the case. As an attorney, as a prosecutor, you have a responsibility to justice. You're not allowed to lie, etc. Oh, yeah. Communication person represent. Let's talk about talking to people who are not your client. Okay, there are two kinds of people. I mean, when you're working a case and you need to talk to somebody, there are two kinds of people: the ones who have lawyers and the ones who don't. Here's the rule: if they have a lawyer, talk to that lawyer. Don't talk to them. If they don't have a lawyer, then the rule is this. Tell them that you are a lawyer. Hey, Reggie, we're wrapping up here probably. We might take a break. We'll see how we're going to go here in a minute. If they don't have a lawyer, then tell them that you are a lawyer. Tell them who you work for. You have to be upfront. You're not allowed to pretend that you don't work for who you work for. You have to be upfront about that, and so on. So when you're talking to somebody on the case, if I call somebody on the phone, they say hello. I don't say hello. I say, hello, my name is Pure. I work for so-and-so. I'm an attorney working in a case of so-and-so. Is this so-and-so? And if they say yes, then the very next question is, do you have a lawyer? If they say yes, then my next question is, all right, what's that person's name? Thank you very much. Goodbye. Click. That's it. You say nothing else to that person. But if they say, no, I don't have a lawyer, then you say, okay, we'll understand that, you're not legally required to talk to me, but I'd like to talk to you, and then you proceed in that way. And by the way, when it comes to talking to people on the phone, you may be in a situation where you have no choice, and it sucks, but ideally, you will have somebody else with you on the phone. Because if that person says something to you, you may need to use what they say in court. And to use what they say in court, the fact that you heard them say it, first of all, you may have hearsay problems, but say you can get around the hearsay problems because there's usually some way around that. Then you can come in and say, then you may have to come in and say, I swear to tell the truth, the whole truth, and nothing but the truth. I talked to so-and-so, and they told me that they were with my client in the hotel room on the night in question. And you can't do that because you are not allowed to be both the trial lawyer in the case and a witness, which means that if something happens on that phone conversation and you
Wait.
get really important information that you need to testify to, you're probably going to end up resigning the case, giving the case to another lawyer so that you can now be a witness. And as a fact witness, you don't get paid. So what you want to do is when you're talking to this person on the phone, you want to have with you somebody else standing by, or you may not even talk to them yourself at all. This is what investigators are for. In fact, it would be really a cool role play idea for Nathaniel and Associates if somebody
Uh-oh.
were to say, you know, I'm not a lawyer, I'm not a receptionist, I am the investigator. My job is to go out and, you know, find people and talk to them. I'm sure that we could. There's enough people in this scene who love to pretend to be cops. I'm sure
I might
somebody
know
would love to pretend to
somebody.
be a PI.
Eh?
So what?
I might know someone. I know a few
Yeah,
people.
it might be a fun position for him to have. Anyway, let's see. Let me talk a little bit about advertising, and then we'll see about breaking or wrapping. Okay, so there is a rule called solicitation. It's sometimes called barratry, or if you want to give it its informal name, it's called ambulance chasing.
Huh.
If you want to insult a lawyer, one insult for a lawyer is to say he's an ambulance chaser. Okay. An ambulance chaser is somebody who is driving down the road and they see an ambulance and they drive up behind the ambulance so that they can follow the person to the hospital and come and say, "Hi, I'd like to be your lawyer." Okay. This is called barratry or solicitation or ambulance chasing. And it is super duper illegal. You do this, not only can you be disciplined for it. Hey, Senny. Not only can you be disciplined for this, but furthermore, you can be, in many states, any money that you make, you have to give it back, and you get sued. And you pay a fine as well. It's a big damn mess. There are exceptions to this. So the thing that was a big thing in my practice is that what the rule says is you're not allowed to ambulance chase with any mind for having to make a profit. If you're trying to make money off the case, you're not allowed to make the initial approach. They have to come to you. You can't come to them. Lawyers, like vampires, can only come in when we are invited. Okay? But if you have no intention of sucking this person's blood, it's okay. But you really have to not suck their blood. What I mean by that is, you can't get paid if you do this, right? If you're watching a TV and you hear a case that just makes you go, "Oh my God, I can't believe what's happening to that poor person. I want to do my part for public service and I want to represent that person," you can go and see that person in jail. You can say, "Hi, I'd like to be your lawyer." And they say, "How much do you want?" And they say, and if you say nothing, 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 nothing. But if you do that, you have to mean it. I've done this many times because I was a protest lawyer and I didn't give a fuck about the money. I just wanted to raise hell. But I would do this and you know, in some cases, you know, I remember I had a client at one point, and yes, I can talk about this because he gave me permission, where at the end of a case where I had, you know, potentially saved a guy a decade in prison, he was just, you know, overjoyed with me and saying, you know, "My God, Pure, let me at least buy you a bottle of scotch." I said, "Nope, can't do it. Can't do it because I came to you. You can't buy me a cup of coffee. I can't take 1 penny from you because if I do, I've committed ambulance chasing and then I'm in deep shit." But let's talk about what it is, because you drive down the road anywhere in the United States and you see great big billboards for lawyers who want to take your case in the event that you're injured. Okay, well, how's that legal? Well, here's the rule. You are not allowed to approach someone with in-person solicitation or its functional equivalent. What do I mean by this? Its functional equivalent means a situation where you would feel a little awkward about telling this person to fuck off. Okay? Think of it this way. if I come up to you and start talking to you in person, say, hey, how you doing?
I'm doing good.
You might feel a little odd to just completely ignore me. So that's not allowed. If I call you on a telephone, most people, that's the functional equivalent, because the idea is maybe not so true today in 2023, when we live with spam calls and all the rest of it, but in the old days, when somebody's talking to you on the phone, it's kind of rude to just hang up the phone. So you're not allowed to be calling people on the phone.
Mm.
But, letters are fine. You can write letters saying I'd like to work for you and I'd like money for the purpose. You can do that. That's fine. You can advertise on TV. You can put the billboards out. Why? Because everybody has the right to just throw the damn letter away. Email is probably fine. Instant messaging chats maybe are a little on the gray line, but I'd probably put that, just in my own opinion, probably on the line of probably okay. But, of coming up to somebody in VR chat, although that's not in person, I think that's its functional equivalent. Because, we all know how to block Nazis, but it's, because it's an ongoing kind of, of thing. It's a conversation. And you don't want to force people into a conversation. Now, why does this rule exist? Well, according to the stated reason for the rule is that, people can end up being represented by lawyers who are not right for them, or, the lawyers are just too greedy, or they're, and these stated reasons are absolute trash. Because, my God, people advertise things all the time. Why should lawyers be any different? And I did the research to try to figure out why really this is. Where does this come from? It comes from the 19th century. It comes from, the Gilded Age of capitalism, the factories where the kids would lose their hand and just be told, get out of here, crying about it. It comes from that period, because what would happen was lawyers would be suing capitalists, basically. They would sue capitalists, and the capitalists didn't like it. So they came up with this rule and got the governments to pass it. Because, if you read your Karl Marx, you know that capital cannot ever afford to pay the cost of social reproduction. In other words, if the billionaires had to pay for all the harm they do in the world, there would be no billionaires. So lawyers are in the business of making people pay for the bad things they do, and so they made this rule. I think it's horseshit, but whatever, because I'm not really a plaintiff's lawyer anyway, and my kind of work was always about just going in to fight because I wanted the fight. So that's that an attorney should generally do pro bono service, meaning work for free whenever you can. If a judge gives you an appointment, you have to take it, and generally what most places do is they write down the names of all the lawyers who are willing to take appointments, and then they give you that. But in theory, any judge can appoint any lawyer to take on any case. And unless they have a conflict of interest, they have to do it. There's a story about a state governor who was trying to cut the budget of the court-appointed lawyers. And a judge, this state governor happened to be a lawyer, as many political people are. And the judge started appointing the governor to represent low-level criminal cases. And the governor said, never mind, you can keep your budget. Okay, so let's see. I think that's all that I really wanted to cover, but I know, Reggie and Cinny and Manny came in pretty late, and so we may go over some stuff. But we've been going a little more than an hour. Normally these classes run an hour. We can do a break. We can do an after party. But right now, let's just open it up to questions. Any questions? Nothing.
So
okay. So, after party?
Sure.
Yeah.
Sure.
Yeah.
Fucking A.